5 seconds to go. Start. The amendment made to GOP number 763 dated 15th November 1975 wide GOMs number 124 dated 7th March 2002 does not leave any room for doubt. 30% of the posts meant for both locals and non-locals have to be mandatorily filled up first before going for the remaining 70%. Similarly, the government clarified wide GOMs number 924 dated 12 December 2007 that all the departments are duty bound to complete recruitment process by adopting the 30-70 ratio, which reads as follows. All the departments are hereby directed to maintain 70% of reservation in direct recruitment to locals in respect of posts gazetted after 1975 after the implementation of the provision of presidential order as per the list appended so as to protect the interests of locals. Therefore, the High Court fell into an error in not only adopting a wrong ratio but also fixing 70% first. On a reading of the notification, it is amply clear that a candidate is not non-suited from being considered in another zone, subject to the only condition that it should form part of the option that she has exercised. This is exactly what respondent number 2 did. Courts will have to be cautious and therefore slow in dealing with the recruitment process adopted by the recruitment agency. A lot of thought process has gone into applying the rules and regulations. Merely because a recruitment agency is not in a position to satisfy the court, a relief cannot be extended to a candidate deprived, as it will have a cascading effect not only on the said recruitment of respondent number 2 but also to numerous others as well. In such view of the matter, courts are duty bound to take into consideration the relevant orders, rules and enactments before finally deciding the case. In this regard, reliance is placed on the decision of this court in Dalpat Aba Sahib Solanke versus B.S. Mahajan 1991 SCC 305, where it was held. It will thus appear that apart from the fact that the High Court has rolled the cases of the two appointees in one, though their appointments are not assailable on the same grounds, the court has also found it necessary to sit in appeal over the decision of the selection committee and to embark upon deciding the relative merits of the candidates. It is needless to emphasize that it is not the function of the court to hear appeals over the decisions of the selection committees and to scrutinize the relative merits of the candidates. Whether a candidate is fit for a particular post or not has to be decided by the duly constituted selection committee, which has the expertise on the subject. The court has no such expertise. The decision of the selection committee can be interfered with only on limited grounds such as illegality or patent material irregularity in the constitution of the committee or its procedure vitiating the selection or proved mala fides affecting the selection, etc. It is not disputed that in the present case, the university had constituted the committee in due compliance with the relevant statutes. The committee consisted of experts and it selected the candidates after going through all the relevant material before it. In sitting in appeal over the selection so made and in setting it aside on the ground of the so-called comparative merits of the candidates as assessed by the court, The High Court went wrong and exceeded its jurisdiction. In the case on hand, we have no iota of doubt that the appellant has correctly followed the mandate of law. Therefore, we are inclined to set aside the impugned order passed by the division bench and that of the learned single judge of the Telangana High Court. Accordingly, the impugned order is set aside and the appeals stand allowed by restoring the recruitment made in favor of respondent number 2. No order as to cause. Stop.